President Trump today using a Washington law enforcement speech to defend his extreme vetting executive order and urge the federal appellate court to reinstate it. The president read out parts of the federal law outlining presidential powers on the matter. Here it is.
Suspension of entry or imposition of restrictions by the president. Okay, now, this isn't just me. This is for Obama, for Ronald Reagan, for the president. And this was done, very importantly, for security, something you people know more about than all of us. It was done for the security of our nation, the security of our citizens, so that people come in who aren't going to do us harm. And that's why it was done. And it couldn't have been written any more precisely.
Well, the president's order is now facing more than 50 legal challenges from various groups, attorneys general, residents, others across the country. And joining me now to sort this out for us, Josh Blackman, associate professor at South Texas College of Law in Houston, adjunct scholar at the Cato Institute, David Rivkin, senior fellow for the Foundation for Defense of Democracies. He served in both President Reagan and George H.W. Bush's administrations. Good to have you both with us. David, listening to those arguments last night, I wondered at the Justice Department attorney who seemed utterly unprepared, unenergized, and certainly he seemed utterly unaware of his opportunities to set at least the factual record straight. Your impression of the performance of the attorneys and the appellate judges?
Well, I would hate, Lou, to criticize in our counsel. I can tell you, for what I understand, because of disqualification of the lawyer who was supposed to argue his case, he did not have much time to prepare. But I would say the government has a strong case, an overwhelming case. If the law was the only issue in play here, it would win in spades, both on the merits, but very importantly on standing. It's my favorite issue. I would say that all three branches of government in our system have constitutional limitations. The judiciary is supposed to hear cases or controversies, which means that the parties bringing it have standing. States have no standing. Their merits arguments are unsustainable. The important thing here is that both Congress and the President, both political branches, are acting in unison. Congress and President Trump quoted a little bit from that section of Immigration Naturalization Act. Congress gave him authority specifically to exclude any and all aliens if he deems it to be in national interest. It is essentially non-reviewable statutory determination. And then he has all of his own constitutional powers in the area of foreign affairs. In that situation, the judiciary has almost no role to play. The last thing I would say, that is not a Muslim ban on the four corners of his document. It is a reasoned decision to suspend entry based upon, Lou, is very important, on the list of 7 countries that were chosen by Congress and the previous administration.
And Josh, to that point, this is an extraordinary time. 70% of the country's 13 circuits, appellate circuits, are primarily led by liberals, appointed by liberal presidents. And we have some people saying, oh my gosh, President Trump is politicizing the process by criticizing those judges directly, whether they be the district court judges, whether it be the appellate court judges, in this case the Ninth Circuit. This is as we listen to these judges on the Ninth Circuit last night, they're pretty politicized already. Your views on how severe is that politicization, and why in the world should the American people not take account of the truth and the reality about the process by which those judges got to those positions in terms of the politics that are played?
Well, the appointment of judges was something that President Obama took very seriously. And in 2013, Harry Reid used what's called the nuclear option to eliminate the filibuster for judicial appointments. And as a result, he was able to make a number of appointments to the courts of appeals of people who would not have gone there but for the filibuster. But what comes around goes around, and now there are over 100 vacancies in the federal courts that President Trump can use to fill and to appoint judges who have a commitment to textualism, originalism, and the founder's vision of the Constitution to help bring the judiciary back in line with where it ought to be.
And the Ninth Circuit, the most overturned, considered to be the most left-wing or liberal, if you prefer, of all of the circuits. What is your expectation as to what they will rule and where the case will go?
So I listened to the arguments yesterday, and at least two of the judges in the panel seemed pretty skeptical of the Trump administration. One judge, Judge Clifton, seemed somewhat more sympathetic to the government's position. But I expect on Thursday, at the earliest, we'll get a ruling in favor of, say, of Washington. And at that point, the Trump administration will have a very difficult choice of whether to go to the Supreme Court or let the process ride out and decide what they want to do. Do they go to the Supreme Court now with 8, or do they let the process ride out and go back when they're 9, when Justice Gorsuch is on the bench? It's a very difficult decision.
Lou, if I can add
Surely.
to this, again, if law was driving this case should be dismissed in its entirety because of the foundational infirmities. I agree with Josh that in all likelihood that would not happen, but I do think they're going to substantially narrow the scope of injunctive relief entered by Judge Robart at the district court level. So while legally, symbolically, it would be very unfortunate, and of course the media would be hailing it as defeat for the Trump administration, I think there's a practical matter that would make the injunction, I should say, more palatable for the administration. And then they would confront the difficult choice that Josh mentioned. Do we go to the Supreme Court now seeking on an emergency basis cert, or do they allow this to go back to Judge Robert and then go to a Supreme Court? Then there are 9 in place.
There is a sense, I think, even amongst left-wing media in this country, that the court the district court in Washington, the Western Washington district, has gone well beyond what he should have done on this, based on the constitutional, as you pointed out, David, the foundation for this ruling is basically non-existent, and the language very clear in the statute.
Right.
So perhaps, what is the recourse for the administration? The president appears to be winning in the public court of opinion, at least. What should be the politics here? Josh, you first.
Well, I think the problem with Judge Robart's decision is that there was no analysis. He issued a momentous nationwide injunction that stopped a massive policy with literally 2 paragraphs. And if you read those 2 paragraphs, there's absolutely no reason why. Does this violate the Establishment Clause? Does this violate the Due Process Clause? Does this violate the Equal Protection Clause? We have no idea. And if the judge had taken an hour with his law clerk to sit down and actually write an opinion, then I can criticize it. But I have no idea what the opinion actually was. And that was really an embarrassment and a shame that the court didn't explain its reasoning.
David,
Yes,
you get the last quick word.
Yes,
if you will.
and as a practicing lawyer, I'm reluctant to criticize judges, but I would say it is an awful decision. I've never seen a decision like this. By the way, the judge also did not point out why, despite the clear Supreme Court precedent, the state of Washington has standing. I think the Ninth Circuit is going to clean it up. I actually thought that the judges on the panel understood what's going on here, so I'm cautiously optimistic.